What are the local rules for filing a car accident lawsuit in the Waterbury Superior Court? If you plan to file a car accident lawsuit in Waterbury, the rules that apply at the start of the case can shape everything that follows. The short answer is that a lawsuit is generally started by preparing a summons and complaint, serving the defendant, and filing the papers in the proper judicial district before the deadline expires. Car accident lawsuits in Waterbury are filed in the Waterbury Superior Court at 300 Grand Street, which serves the Waterbury Judicial District. Under Connecticut law, venue usually depends on where the plaintiff or defendant resides if either party is a Connecticut resident. If all parties live outside Connecticut, the case may be returned to the judicial district where the injury happened. The Waterbury Judicial District covers Middlebury, Naugatuck, Prospect, Southbury, Waterbury, Watertown, Wolcott, and Woodbury. Some towns have more than one venue option, including Watertown, Woodbury, Plymouth, and Southbury. That means a lawyer may be able to choose between districts in certain cases based on the available statutory options. Returning a case to the wrong location can cause delay and may require correction or transfer, even though it does not automatically defeat the claim. Connecticut handles the filing process differently than many states because the defendant must usually be served before the papers are filed with the court. The two main documents at the start are a summons on Form JDCV1 and a written complaint. The summons must include a return date, and return dates in Connecticut must fall on a Tuesday. The complaint should describe the facts of the crash, state the legal basis for the claim, and explain the damages being sought. Each factual allegation should appear in a separately numbered paragraph. Service of process is typically handled by a Connecticut state marshal, although the statutes also allow certain other proper officers authorized by law. For an individual defendant, service may be made by leaving a true and attested copy with the defendant or at the defendant's usual place of abode in Connecticut. After service is completed, the papers must be returned to the Chief Clerk's office at Waterbury Superior Court or e-filed when electronic filing is available for the filer and case type. Connecticut generally gives you 2 years from the date of injury to file a car accident lawsuit. There is also a 3-year statute of repose that acts as an absolute outer limit from the date of the accident itself. In some situations, the discovery rule may affect when the 2-year period begins, but the 3-year cutoff still applies. Certain tolling rules may matter when a defendant's absence from Connecticut prevents service, although substitute service may still be available in some motor vehicle cases. Connecticut also follows a modified comparative negligence rule in car accident cases. That means you may still recover compensation as long as your share of fault does not exceed 50%. If you are found 51% or more at fault, you are barred from recovery. When fault is shared, your damages are reduced by your percentage of responsibility. Once the case is filed, the defendant has 2 days after the return date to file an appearance and generally 30 days after the return date to file a responsive pleading. After pleadings close, the case enters discovery, where the parties may exchange interrogatories, requests for production, depositions, medical records, insurance information, and other evidence relevant to the crash. A lawyer or attorney who regularly handles these cases can help avoid mistakes involving venue, service, return dates, and deadlines, and an attorney or lawyer from a law firm that manages injury claims in this court can also help present evidence that affects fault and damages. For guidance from a law firm familiar with these rules, contact DeFronzo and Petroskey, PC at 203-756-7408 or visit the office at 255 Bank Street No. 2B, Waterbury, Connecticut, 06702, United States.